Yes, a big welcome to everyone. Thank you for joining us today. It's great to see so many of you joining us, and I think from all parts of the world as well. I see from our registration list there's people from lots of different places around the world joining. Feel free to use the chat function to introduce yourself, tell us a little bit about yourself and maybe what job you do, where you're joining us from. That would be great to see. My name is James. I am the course advisor for the Online International Commercial Technology Law LLM that we do here at the University of Manchester. So I think one or two of you will have spoken to me already over email, or possibly we've had a consultation together. I'm here to give you advice about your applications and guide you through that process. So feel free to contact me at any time after this webinar as well. You'll see my email address on the presentation. It's studyonline@manchester.ac.uk. So you can use that to contact me about the course. I'm also joined by Dr Fiona Brimblecombe, who is a lecturer on this course and also a unit lead, and has created a lot of exciting content for one of the units on this course. So she will be introducing some of the topics in that unit today and giving you a bit of an insight into the right to be forgotten and the legal ramifications associated with that. And we'll also explain a little bit about how that is covered in the course and how this LLM can enhance your understanding of similar topics. Fiona, would you like to just give a quick introduction to your background, your research interests, and your role on the course, please?
Yeah, so hi everyone, and thanks for coming. So I'm an academic at the University of Manchester, as James has said, and my area of research or specialism are the personality torts, and torts in sort of English law and UK law are civil wrongs. And in particularly, I write on privacy and defamation of character. And privacy, all my work is really about privacy in the age of the internet, because it struck me a number of years ago when I started to write my PhD that there was a fundamental problem with the way that privacy rights were being dealt with online. In other words, there was a lacuna, there was a gap in the law. How are we able to actually retract some personal information about ourselves on the internet if it's out there? How is someone able to do that, circa 2023? So everything I've written and published so far has been examining this, I think, very crucial area in today's sort of digital world. And the right to be forgotten is one potential remedy that European citizens can use to try and claw back some of their privacy rights online. And that's why it interested me so much. And as James has also said, I will mention a little bit at the end of this presentation, because I'm just going to give a paper today. So I'm going to explain what one of my previous articles was really about in relation to this. But I will explain a little bit about the unit that I've written for this new online LLM, which centres around the torts of personality and data protection in the digital age, both in the UK and the EU. So shall I get going, James? Shall I give?
Absolutely, yeah, thank you. Yeah, that's a great introduction. Yes, please feel free to start your talk. And yeah, I'm excited to learn a little bit more myself.
Yeah, lovely. So can I change the slide? Have I got control? Can I?
You should have control now, yeah.
There we go. Lovely. So what I'm going to talk to you about today, as I've sort of briefly explained, is some of the work I've done in the past on the tort of misuse of private information. And that's English law, that's common law, it's judge-made law in the UK, and how this may converge with the GDPR, and in particular, the right to be forgotten within the GDPR, it's in Article 17, in terms of modern actions relating to personal information being divulged on the web. So this paper, it's broadly based on an article that I published last year with a colleague of mine from the University of Durham, Professor Helen Fenwick, and we published it in the Northern Ireland Legal Quarterly. And we published a second article as well, specifically on remedies in the Law Quarterly Review, which is Oxford's original law journal, a couple of months later. So we ended up actually embarking on an enormous project thinking about how the more traditional, old-fashioned civil tort law of misuse of private information is going to work in the modern world alongside European data protection law in the English jurisdiction, because we were aware that, we didn't think enough was being written on this. So the paper I'm going to talk about today charts or explains some of the missteps, in my view, that have been taken by the English and Welsh courts when shaping the tort of misuse of private information. And what the paper does is it suggests how this now teenage, so it's about 19 years old, the tort of misuse of private information, is going to sit alongside the new right to be forgotten that stems out of the GDPR, as well as the GDPR as a sort of a massive law in general, and how one regime or system may shape the other. And before we go any further, I think it's important to sort of do some housekeeping, because I'm aware that I'm going to be using some sort of legal terminology, and I think I have to briefly explain what both misuse of private information on the one hand and the GDPR and the right to be forgotten on the other are. So, first of all, what is misuse of private information? Well, in short, it's the closest thing we have in England and Wales to a tort of privacy. And it's the strongest course of action, in my view, that an individual can pursue in order to protect their informational autonomy online, or at least it was until the GDPR and the right to be forgotten came along more recently. Now, the history of this tort of misuse of private information is sort of quite lengthy and well trod. But in short, the English courts were for quite a long time resistant to the idea of having a sort of law of privacy, a tort of privacy in the English jurisdiction. But after the Human Rights Act came into force, this pre-existing equitable action for breach of confidence in English law gave birth to this new tort of privacy, this new tort of misuse of private information. And a string of case law charted this creation of this new tort of misuse of private information. I don't have time to sort of go into a huge amount of detail, but that's a few cases that did that on the slide there. And the shift really came to a head. It culminated in a seminal case called Campbell and MGN about pictures of Naomi Campbell, in 2004. And the House of Lords, the highest court of the land as it was then, named the new tort formally in Campbell. And academics have commented on this at length, and Rowbottom, who's Professor of Law at Oxford, he's noted in the past that the law lords in the case moved away from a more confidence-based discussion to a more human rights-facing assessment in Campbell, with a focus in the sort of language of the judgment on autonomy and dignity that really signalled a fundamental shift in the law. However, since this sort of seminal case of Campbell and the naming of the new tort, I would argue that the courts have been struggling around the scope and formulation of misuse of private information ever since. So, on the other hand, what else are we looking at today? Well, what is the GDPR and the right to be forgotten? Well, I'm sure many of you at this point will have heard of the GDPR. It's the EU's General Data Protection Regulation 2016, and it was centrally introduced to fix the patchwork nature of the EU's previous data protection regime, which was also quite old at the time. And I'm particularly interested in Article 17 of the GDPR. And I should also say, this is retained law in the UK after Brexit, and this allows data subjects to obtain from data controllers deletion of personal data concerning themselves online. And the right, if you actually read the GDPR at length, is very broadly framed in the original text. So The point of the article we wrote was to identify some of the mistakes that the English courts have made when shaping the tort of misuse of private information, and what should be changed now we've entered this new digital era. And we have a new privacy-based remedy of the right to be forgotten in the GDPR. In other words, are we going to see a shake-up now in English tort law as well because of this new remedy? And it's likely that when actions are brought to the courts, and we're seeing this more and more every day, regarding personal and private information on the web, that one claim, will seek to invoke both rights together. They'll try and run a misuse of private information argument under the old English tort law, and they'll also try and run a data protection argument as well. So judges are going to be considering these claims over privacy interests in different ways in tandem. And we did see that a little bit even a number of years ago under the old regime, under the Data Protection Act 1998 and the 95 directive. And in fact, the courts have even acknowledged this. So there's a little quote there you can see on the slide from Lloyd and Google, the Court of Appeal. And the courts have acknowledged actually that both of these sort of areas of law, misuse of private information on the one hand and data protection at the EU level at the other, they're both parts of the same European privacy protection regime. So what are they going to learn from one another? That's the question. So, well, in order to understand how the tort of misuse can be influenced by the right to be forgotten in the GDPR, we need to have an understanding of some problems, in my view, that the tort's developed over the years. So the first mistake or misstep, that I want to talk to you about today, in my view, is acceptance of weak free speech arguments by the courts. So the first big problem is the erratic nature, in my view, of misuse of private information judgments in their prioritisation of press freedom. So when misuse of private information first started out with judgments like Campbell, like McKenna and Ash, there was a balancing exercise between, on the one hand, privacy rights and on the other, freedom of expression interests. And I thought that balancing exercise was very equitable in the early cases like Campbell, like McKenna. So, for example, the importance of Naomi Campbell's medical records and their obvious private nature was not lost on the courts in Campbell. And Lord Justice Buxton in McKenna highlighted the importance of Strasbourg, so European Court of Human Rights, Article 8 jurisprudence to bolster the decision. However, the trajectory of misuse case law hasn't been entirely positive from a privacy advocate or a claimant's perspective. Some later High Court decisions of the English courts have shown a tendency to accept weak public interest arguments and prioritise these over the privacy rights of claimants, which skews a genuine balancing of different interests, privacy on the one hand and expression on the other. So notable examples of this that I want to draw your attention to are in the footballer cases, as I like to call them. So they're present in the cases of Ferdinand and Terry. There's Rio Ferdinand there on the screen. So in both cases, the court accepted the tenuous notion of what we call the role model factor. And they said this role model factor being present legitimised the publication of details of both John Terry and Rio Ferdinand's extramarital affairs. It was successfully argued that as both Terry and Ferdinand, as prominent footballers in popular culture, had young fans, this information about their personal lives had public interest value. That was despite the fact that neither had engaged in illegal conduct or behaviour that in any way meaningfully affected the public. So, what's the upshot of this then? Well, the sort of result of these media-centric decisions like Terry and Ferdinand in misuse of private information has been to, in my view, erode the protection for personal privacy offered by misuse as a tort. And Mead, who's another academic, has also observed, I think quite correctly, that various private interests, such as lascivious interests in the sex lives of the rich and famous, have been bundled into judicial decisions concerning what constitutes the public interest. And that's evident in decisions like Ferdinand and Terry. And that runs contrary to Fenwick and Phillipson's approach, who are two sort of leading academics in the area. They argue that only genuine arguments of important public interest should be tolerated by the courts, not flimsy ones like we've seen in the past. So, are we going to see a change in approach then in this new era of the GDPR in relation to this role model factor? Well, you could argue that part of the reason that these two decisions, Terry and Ferdinand, were decided like they were was because misuse of private information as a tort has a media-focused design. And through judgments like Terry and Ferdinand, the courts have prioritised the symbiotic relationship celebrities have with the press. And as a result, protection of privacy rights, according to Article 8 of the European Convention, have at times been overlooked. In contrast, the GDPR has a personal privacy-focused design. So there's a significant difference between the idea of private information under the GDPR and this difficult test of establishing what we call a reasonable expectation of privacy in order to rely on misuse of private information as a tort. So in order to rely on the right to be forgotten, the right to erasure of your personal information under Article 17 of the GDPR, all one needs to prove is that the data in question is their personal data as a starting point. And if we look at Article 4.1 of the GDPR, that categorises personal data as any information relating to an identified or identifiable natural person, a data subject. That's a very transparent, clear and accessible approach to the deletion right, very much in contrast to this idea of reasonable expectation of privacy that has arisen out of misuse of private information as a tort. And one of the things we've argued in the article is that this radically different approach of the GDPR in this respect may influence English judges to take the misuse tort in a different direction, away from its more press-centric roots. In effect, the simple and clear approach of the GDPR to who can invoke a right to be forgotten may impact also the court's later approach to this idea of, the REP test, the reasonable expectation of privacy test in misuse of private information, and work to dilute it. It also may impact how this balancing exercise is conducted too, between privacy on the one hand and freedom of expression on the other. And it may dilute it in terms of actually lowering the hurdle that claimants have to jump over in order to demonstrate that the data in question is sensitive and deserving of privacy protection under the tort. And I think this is particularly pertinent given the fact that we're now in the internet age, right? The privacy claims of the future will often, if not always, involve the web and private individuals, rather than more traditional misuse of private information actions, which celebrities have been at the heart of in the past. So, what do I want to moan about second? What's my second criticism? Well, it's a doctrine called Waiver. So, I'm just going to take a sip of water. In a handful of cases from the 1970s onwards, in breach of confidence, which was an equitable action which existed before the misuse tort, and in the misuse tort case law, English courts have created a doctrine of implied waiver of privacy rights. Okay. And what this doctrine assumes is that an individual can negate, so forego, their right to privacy through their own previous solicitation of publicity. Okay, so the doctrine itself is deeply problematic. Just because a person has disclosed certain private facts about themselves publicly in the past should not mean that the press have carte blanche to disclose other pieces of private information about them in the future. And, you know, to add even more confusion into the mix, because these things always become more complicated rather than less complicated as the years go on, the courts haven't even been consistent with their application of this doctrine. So first of all, as you can see on the slide there was a broad approach, as evidenced in a case called Woodward and Hutchins, you can see there. And what the broad approach dictated was that any prior discussion to the press would mean that a request for privacy in the future would be in effect nullified. Right? That's the broad approach, quite draconian. You can see the quote there from Law Bridge and Hutchins in 1977. Those who seek and welcome publicity of every kind, bearing upon their private lives, so long as it shows them in a favourable light, are in no position to complain of an invasion of their privacy. And then on the other hand, we've had a more narrow approach as well, exhibited by the courts in A and B, for example, which we call the notion of zonal waiver. And here, a key consideration of the courts is the type of information that that person has previously disclosed. And if it's of the same type or in the same broad zone as information that a defendant publication wants to publish on or has published on, then a claimant's reasonable expectation of privacy could be seen as being waived, so being given away, being nullified, right? So the idea of zonal waiver lives on. It was mentioned in the more recently decided case of Cliff Richard in 2018, although it was conspicuously absent from another very high profile judgment a few years previously called PJS. So we don't know, maybe we are going to see some change in this regard. And you can see, I won't read it out, what Mr. Justice Mann says in Cliff Richard about waiver. He's discussing a more narrow aspect of waiver here. Okay, maybe more in line with zonal waiver, right? Like A and B that we discussed before. Now, the doctrine of waiver is problematic for several reasons. So firstly, it's unjust to say that because a person has chosen to disclose one piece of information about a particular aspect of their private life in the past, that they have relinquished control over other pieces of private information about themselves. Far from it. You know, I think it's far more logical to argue that autonomy and control over the remaining information should be maintained, as that person has specifically chosen not to disclose it. And regarding this idea of zonal waiver that I mentioned earlier, well, there may be particular reasons why a person is happy to disclose a certain fact, but not another, still within that same zone. So, what changes could the GDPR bring then? Well, typically, there's no reference to prior disclosure of their own personal information by data subjects under Article 4.1 of the GDPR. Article 17 said the right to be forgotten in the GDPR was clearly designed to avoid distinguishing between personal data initially uploaded by an individual themselves to the web and data uploaded about someone else by a third party, okay, which runs contrary, in my view, to this notion of waiver. It simply states that the data subject shall have the right to obtain from the controller the erasure of personal data concerning him or her without undue delay, where a number of grounds applies, including a situation in which a data subject withdraws consent on which the processing is based. And that would include instances in which a subject has changed their mind after initially disclosing personal information online themselves. And I think all of this suggests that waiver is in fact an outdated notion in this digital age, certainly where the GDPR is concerned. And this approach of Article 17 here may well influence, I think, the English judiciary to put waiver to bed once and for all in misuse of private information jurisprudence. Because I would say, it's been withering on the vine for a very long time. And instead of actually prioritising this idea of waiver, a more important factor the court should actually consider, in my view, is the harm caused to a data subject by that disclosure of information, as was suggested by PJS, a very high profile decision by the Supreme Court a number of years ago. Right, so the final thing I'd like to complain about in misuse of private information is the concept of the public domain, or the public domain doctrine. So this doctrine provides that if the private information is deemed to be already in the public domain, then it's less likely that the courts will find that a reasonable expectation of privacy exists in respect to it, and therefore an MPI, a misuse claim, would fail. So this doctrine is particularly problematic with regards to online dissemination of private information. As we all know, information data can be spread quickly and rapidly on the internet. So the doctrine, the public domain doctrine, as traditionally stated, dictates that if the personal information is already known to the public to an extent that a court deems significant, then the information has lost its private quality and should no longer be protected. And academics Butler and Ragg, Paul Ragg at Leeds, have both found that the doctrine clearly derives from an all or nothing analysis that can be found originally in the annals of history in breach of confidence actions, where we know misuse of private information originally emerged from. And much like waiver, the doctrine I just discussed with you earlier, the English courts have applied this concept of public domain erratically. It's far from absolutist. So as you can imagine, this doctrine presents an even greater problem with how it works alongside online disclosures of personal data or private information. How many people have to have seen this information for the doctrine to be operable? Well, in a case, I've named a couple of cases there on the slide for you. In Martin and Oars, publication to a private Facebook account where viewers are controlled was not found to have placed the information in the public domain. And then in Rock and Roll, the initial post in question was to a private Facebook account. And this could be viewed by approximately 1,500 friends. And it was determined in Rock and Roll that there was still something private left to protect in that information. And in the more recent sort of seminal case of PJS, the information was said to retain its private quality, despite the fact it had been the subject of several articles outside the jurisdiction and had been widely disseminated online. So the courts are really struggling, I would say here, with how to use this doctrine in the modern day and apply it in this online context. So how is the right to be forgotten in the GDPR going to change anything? Well, there's no reference to prior dissemination of personal data in Article 4.1 of the GDPR. Information already widely disclosed is still personal data. We've contended in our publication that attempts to apply this doctrine in the online context should now be definitively abandoned in misuse of private information in the digital age. The idea of sort of seeking to count the number of views of a tweet in order to decide whether the doctrine applies approaches the farcical. I think a better alternative, again, to this approach is to consider what further harm could be done by yet wider dissemination of the information in question. Okay, indeed, this was the approach in PJS. And this approach would bring the talk closer in line with the GDPR and may well be favoured by the English courts in future when a claim comes before them as using actions under both the GDPR and the tort. So that's all I wanted to say about my article. If you're interested in reading more about that at length, please do go on my personal staff webpage, Fiona Brimblecombe at the University of Manchester. I'm an academic in the law department. It is open access on the Northern Ireland Legal Quarterly's website. It's about sort of 40 odd pages long, and it's quite a long and detailed read. And we wrote a second article as well that was published last July in the Law Quarterly Review, which just looks specifically at remedies in misuse as a tort and the right to be forgotten. And that's accessible, I believe, via Westlaw if you've got a subscription. So, yeah, and other articles I've written on the right to be forgotten as well in the past, a lot of which are open access now, are also available via my website. So if you're interested in reading any of those, please do. So, I just want to finish, as James sort of indicated earlier, by having a sort of brief explanation of how this all relates to the online LLM in international commercial and technology law at Manchester. Well, I've written specifically a module for this new LLM, and if you start in September, it would launch in February. It's Unit 2, and it's the second one on the bullet point list there under contents, online privacy, defamation, and data protection law. And I've just given you today a real snapshot of some of the issues that we'll be considering if you undertake that unit with me. We are covering privacy at length in terms of the right to be forgotten in the GDPR and the English tort that I've given you a flavour of today. And also we're looking at defamation at length, which I know is very much sort of in everyone's minds at the moment with all the celebrity cases like Agatha Christie, Depp and Heard, etc., that have very much been in sort of the public conscience recently, and online defamation in particular I'm interested in. And then finally, I'm covering sort of an introduction to data protection law insofar as it relates to online privacy interests. So that's some of the content, just a bit of a flavour of some of the content that you'll be studying if you join the LLM under my unit. And you can see there, and that's just one of the many units offered by the LLM. We've got commercial law in terms of corporations in technology, financial law and fintech, financial technology law, IP in a digital context, and a longer research project in terms of a dissertation. So yeah, so that's all I wanted to say, really. Do you want to take over, James, or are we going to take questions? Or
Yeah, absolutely. Thank you very much for that, Fiona. That was very insightful and very interesting. Yeah, we're definitely welcome to take questions from anyone who has them, for sure. Please feel free to post them in the chat or the Q&A function. It'd be great to hear some of your thoughts on that topic. I had a few thoughts myself. I mean, I found it really interesting when you mentioned about the sort of more traditional approach that was taken by the courts. It almost sounded a bit like the judges were saying, especially with the celebrity kind of cases, that all publicity is good publicity, so you should just accept what people write about you. And yeah, it definitely overlooks the idea that, you know, they are also human beings with feelings.
Yeah, I think it does. And it's particularly shocking when you consider that You know, the courts are where they are because it's human rights interests that have really driven this adoption of a new tort of misuse of private information, the idea of private and family life, that everyone should be able to be free from scrutiny in certain aspects of their lives. And then you've got a court actually being quite draconian with the idea of, well, you know, you wanted to play with the dragon and now you're getting burned. It's like,
Yeah.
well, it was quite surprising. I think the courts adopted that so stringently, but they did. Yeah.
Yeah. They sort of said, you know, you've signed up for it, so accept it. Yeah, it's
yeah,
a harsh approach. We've had a question from one of our audience members. So they've said, what is the broadest scope of coverage for GDPR? In the sense that, so other than EU citizens and residents, who else do we as a business have to consider in protecting their GDPR privacy rights, such as the right to be forgotten?
So it's European, and if you're dealing with sort of business dealings that are linked to Europe, so obviously it's a supranational law in the sense that it covers the EU and the UK as well now, post-Brexit. As I say, it's retained law in that sense. We've got the UK GDPR now. I think the GDPR would like to think it has, to an extent, an extraterritorial effect. But to what extent that really is true, I'm not so sure, because that all depends on the third-party countries themselves, because obviously it's going to be very difficult to make a third-party country and enforce a law that they don't recognise. So, you know, what I think is interesting about the GDPR is that it's the first example of its kind of a massive overarching data protection regime that will impact a number of countries under its umbrella, in other words, European countries. And what we have seen is, although it may not have effective extraterritorial effect outside of that, it has inspired a lot of other countries that are not part of the EU bloc to actually adjudicate similar laws, write similar laws and implement similar laws themselves. So it was a pioneer in that sense. It came very early. Although I think you could also say it's in need of an update now.
Yeah, thank you for that. And please, anyone else who has any questions, feel free to add anything there. That's great. I'll just run a quick poll for our audience members, just as a quick question to ask anyone who's interested in the LLM, online LLM course that we run. So you can arrange a consultation with me to learn more about that course. So just that will run for the time being. Yeah, I think it's interesting that there is a lot, you mentioned a lot of potential changes that is going to come about, and it's quite interesting when you mentioned about the time factor of, you know, when these, especially in the case of celebrity stories, we've seen some this year, some big ones in the UK. Most people know what's happened eventually, but then it's because it's kind of been given time to disseminate, and everyone has picked up on it. But if the process of actually removing your personal data takes a long period of time, you're given that window of opportunity for things to spread and everyone to learn. And then it says, well, no, we can't bring it back now, so it's just out there, and that's all we can do. So yeah, it's good that possibly there's some that's been taken into account with new approaches, perhaps.
So we touched on this, not in the paper I just given, but in the second one that I mentioned, in the LQR and the remedies. And you raised, James, a really interesting point, which is, what are some benefits or weaknesses using the tort versus the GDPR in the English jurisdiction? And one thing that the tort has going for it massively, that the GDPR does not, is that there is an ability to obtain a super injunction in this country, which will stop a headline ever hitting the press. We would never know if one was operable, and so that initial disclosure never happens. Okay, now the rights we've got in the GDPR cannot, ostensibly, as far as we know right now, do that. It very much is framed like an ex post right, so that information is already there, and then you are later, you know, attempting to take that down with maybe some more mixed success. So we made quite a cheeky argument in our LQR article, which really said that, you know how I was talking about both regimes can learn something off the other if the courts decide they can, that actually could an injunction requirement be read into the UK GDPR, mirroring its cousin in the tort, to make it even more sort of powerful in that way. Because this learning can go both ways. I've talked a lot about what can the tort learn from data protection, but actually maybe what can data protection learn from the tort that the tort does right as well. Because I've been very negative, I'm aware, about the tort today, but it's not that simple.
Sure. Yeah. No, that's interesting that, you know, there's hopefully taking a bit from both might be the way to go. Great. Yeah. Thank you for that. Again, I'll just quickly run over a little bit more information about the LLM, the online LLM course that we do offer. Fiona's given a really nice introduction to some of the academic content on that course. I'll just give you a few more details about the logistics of studying. So there's a fully online master's degree, which will take you 24 months. And so you'll start in September, you'll run through the 4 units, and then you'll do your final dissertation in the final 6 to 9 months of the course. Most people on the course are already in full-time employment, or maybe have just finishing their undergraduate studies. And so we've set it up in a way that you can do it alongside your work commitments or any other commitments that you have. So we recommend about 15 to 20 hours of work per week. So, you know, it's quite a flexible course, and a lot of our students find it quite easy to do that alongside their other commitments. So our next enrollment is September 2023. So you have a few more weeks to apply. The deadline, I believe, is September 4th for the applications. So please, if you are interested in applying for September 2023, to get your application in as soon as possible, so you don't miss that deadline, and also that you'll have a little bit of time to get everything processed before your classes start in September. There are some scholarships and bursary things available, so you can contact me for more information about that. And also your fees are paid in instalments to help spread out the cost of the programme throughout your studies. If you want to learn more, or we can also set up a consultation to discuss the course further with me, just please feel free to email me at studyonline@manchester.ac.uk. And I'll be happy to provide you with any information that you need. But again, thank you for joining us today. And thank you, Fiona, for sharing that great insight and also an introduction to the course. It's great to see that. Thank you for that. And yeah, we look forward to seeing some of you applying for us in September, and also look out for future webinars going forwards. Thanks for joining. Bye for now.
Thank you. Bye.